Good evening. I'm David Axelrod, the founding director of the Institute of Politics. I don't know who wrote this, but founding director sounds so much better than departing director, so thank you, whoever did that. I'm personally so pleased to welcome you to a discussion with U.S. Deputy Attorney General Lisa Monaco, because we've known each other for a long time. I knew her when she was the Homeland Security Advisor to President Barack Obama. I can tell you that she is a brilliant lawyer, as you'd expect from a graduate of the University of Chicago Law School, but also a person of impeccable integrity and character, which is really what you hope for in positions such as the one she holds today. And Lisa, we're so happy to welcome you back to campus. Before one of our students formally introduces our guests in a few minutes, I would like to mention a couple of upcoming events we have at the IOP and go over some housekeeping notes. On Tuesday, May 10th, New York Times reporter David Farenthold will join us to discuss, I should say Pulitzer Prize-winning reporter, to discuss the impact of modern political and investigative reporting in a conversation moderated by Marianne Ahern, the political editor of NBC Chicago. That event will be at the Quadrangle Club at 5:30, and dinner will be provided. And I just want to say one word about this event. This is the annual Broder event. It's named for David Broder and his wife Ann, both deceased, but distinguished alums of the University of Chicago. And David Broder, of course, was one of the preeminent, really the gold standard among political reporters of his generation. They were great benefactors of the IOP, and we honor them and the importance of journalism every year, and this will be that event, and I encourage you to attend. On Wednesday, May 11th, New York Times reporter Mark Walker will lead a training session on investigative journalism at the Institute of Politics, Journalism Week at the Institute of Politics, because the following night, New York Times reporters Jonathan Martin and Alexander Burns will join us to discuss the two-party system and the current state of democracy as they discuss their new book, This Will Not Pass, Trump, Biden, and the Battle for America's Future. That event will take place also at the Quadrangle Club at 5:30 p.m., and I'll be moderating that discussion. After tonight's moderated discussion, we'll open the floor to take questions from the audience. Please line up to ask your question at the microphone. I believe it'll be in the center. If it's not, I made it up. As usual, we'll give priority for the first questions to our students. And as a housekeeping note, please make sure your phones are silent. Second housekeeping note that is never in here, but I always add, please make sure that your questions actually end in a question mark. We will now hear formal introductions from Eliza Martin, a first-year law student at the University of Chicago, probably a future Deputy Attorney General. Eliza is from Texas and recently served as an aide at the Office of State Representative Donna Howard. Please join me in welcoming Eliza to the podium.
Thank you so much to our two guests and everyone here for joining us tonight. My name is Eliza Martin, and I'm a 1L at the University of Chicago Law School, originally from Austin, Texas. So tonight we're joined by Deputy Attorney General Lisa Monaco and Professor Genevieve Lakier for a discussion on the Department of Justice role in the defense of democracy. Deputy Attorney General Lisa Monaco is the Department of Justice's second-ranking official and, importantly, an alumna of our law school. Deputy Attorney General Monaco is a 15-year veteran of the Department of Justice. She began her legal career as counsel to Attorney General Janet Reno before serving as an assistant U.S. attorney for the District of Columbia. Continuing her career in public service, Deputy Attorney General Monaco also served as Chief of Staff to FBI Director Robert Mueller, as the Assistant Attorney General for National Security, and then as President Obama's Homeland Security and Counterterrorism Advisor from 2013 to 2017. As the Homeland Security and Counterterrorism Advisor, she coordinated the executive branch's policy response to security issues, including all response to international and domestic terrorist incidents, natural disasters, and all aspects of policy and strategy. Now, in the Deputy Attorney General's current role, the Department of Justice's litigating and policy components, law enforcement agencies, and U.S. attorneys all report to her. Professor Genevieve Lakier is a professor at the University of Chicago Law School. She holds a JD from NYU School of Law and also served as a law clerk on the Sixth Circuit and Southern District of New York. Professor Lakier is also an alumna of the University of Chicago, as she received her PhD in anthropology from the university. Professor Lakier teaches and writes about freedom of speech and American constitutional law. Thank you again to both of our guests for joining us tonight, and please enjoy the event.
Well, it's a pleasure to be here to talk to you and to welcome you back to the University of Chicago, where you spent, I'm sure, a very happy 3 years, totally stress-free.
I did.
As a law student.
I loved going to law school here. I like to say I had a strange reaction to law school, which is to say I enjoyed it. I really, really, really liked it. And it was great to be back at the law school. Now, it does help that it's a gorgeous day, and the campus seems to be a lot nicer, a lot leafier, a lot sunnier. People seem much more chill than when I was here. So it's great to be back.
Not that chill, though. It's still the University of Chicago.
True.
Well, let's see.
Yeah.
So the title of today's conversation is Justice in the Spotlight, which I'm going to use my moderator's privilege to interpret to mean how do you do justice in the spotlight of a highly politically polarized time. You know, this question of how one acts as a lawyer at a time of deep political division is one I think about all the time in my job as a law professor, when my job, you know, particularly at the University of Chicago, it prides itself on this, is moderating a vigorous and open discussion between students of very different political perspectives. But, you know, over the past few years, I found this a much harder job to do as students have become so profoundly divided and distrustful of one another. And I imagine it's a problem that is exponentially more difficult to do when you're helping to run the Department of Justice. So today I wanted to ask you about how you navigate the partisan divides and the pitfalls of life in contemporary United States in your job as the Deputy Attorney General. So I thought I would start by asking you what you conceive the Department of Justice's role to be in the contemporary landscape. You've said that the DOJ holds a, and I'm quoting you here, a unique place in the federal government because it is an executive agency that wears two hats. First, it is an executive agency that implements the president's policy objectives. Second, it is an independent investigator and prosecutor and must act free from any political or partisan influence. Now, there's obviously tension between these two hats, these two goals, particularly, I think, today when Americans of different political stripes differ so profoundly in their view of the role of the federal government, what it should be doing, and about what it means to enforce federal laws in a non-political manner. So I wanted you to ask you sort of generally about running the DOJ at a time of intense partisan division. How do you make ordinary Americans believe that you're acting in a partisan-free way, and how do you actually do it?
So in typical law professor fashion, she's started with a really easy question.
Yeah,
Way to
it's
just
much
kind
tougher
of,
from here.
and not a multiple choice answer. So first, since you're a free speech scholar, I'm happy to say you quoted me accurately. Look, first of all, I'm going to be a little bit contrarian and say I actually don't think there's tension in those two hats, and I'll explain why in a minute. But I grew up as a lawyer in the Justice Department. Literally, my first job as a lawyer after my clerkship was as Eliza, and thank you very much, Liza, for the very kind and generous introduction. As Eliza laid out, my first job was counsel to Attorney General Janet Reno. And she was no denizen of Washington, D.C. She was like the very opposite of a D.C. insider, right? She'd been the state's attorney in Miami, done very innovative things like the first drug court, things that are now pretty commonplace, luckily, in state and local justice systems. So she'd been an innovator, and she came to Washington, was a total fish out of water. But she ran the department very, very conscious of these two hats, and that's where I got my education. And I got my education on the unique role of the department, which has helped me to navigate all of the roles I've had in the department, and I think prepared me for this role. And this is why. Janet Reno hung a portrait of a guy named Ed Levy in her conference room. I see nods in the audience. Good, you have now passed the first test. Ed Levy was, of course, the dean of the law school, the provost of this great university, and the president of this great university. And he was plucked from these hallowed halls after Watergate to become the Attorney General. And you students of history will know that we think things have been tough, and I know a lot of people think things have been tough in our political system and in our justice system and in the last several years, but Watergate was a real body blow to norms and traditions and was a real tough time for the Justice Department. And so Ed Levy came on board as Attorney General after the Saturday Night Massacre, and President Ford asked him to take the helm to kind of restore the department. And he put in place a kind of foundation that many of us who've now become leaders in the department look to as our kind of North Star. And Attorney General Reno did that, and that was my first education of the department. So the reason I say that there is not tension between these two hats is I think it's completely reasonable to, although unique in the Justice Department, and the Justice Department is unique in our system of government, in our federal system, of being the only cabinet agency that does wear these two hats. So on the one hand, we are independent investigators and prosecutors in our criminal enforcement role. And we have to do that job completely free, certainly of partisan or political influence, but frankly of any external or extrinsic influences, right? Without regard to who is the defendant, without regard to our own personal views about a particular law. We have to apply the facts and the law and do so in an even-handed manner and consistent with the principles of federal prosecution. Pro tip, those of you who want extra credit, go to Google and Google Principles of Federal Prosecution, and you'll see the guidance that federal prosecutors adhere to in fulfilling this independent prosecutorial function. So that's one hat. The other hat is, regardless of that function, we also have a responsibility as an agency in the executive branch to pursue, as long as they're lawful, the policy priorities of the president. Whoever he or she is who decides these are the policy priorities, we march forward and pursue those. And that's completely appropriate. The reason I say they're not in tension is because this is how we navigate it. It is completely appropriate for the president to say, okay, Justice Department, I want the policy priority to be pick an enforcement issue. Violent crime, healthcare fraud. I want you to put your resources on that enforcement issue. I want you to make that priority. Okay, and we can quite appropriately do that. What can't happen is for the president or some other political actor in the administration to say, and Genevieve, I want you to prosecute that hospital and that executive of that healthcare system for whatever reason. That's where those two streams cannot meet. So I don't think that there is tension in these two hats. There is a challenge in making sure that we are constantly, on the one hand, acting consistent with the principles of federal prosecution and not undertaking our enforcement mission pursuant to any political or partisan or other extrinsic consideration, but we can also fulfill those policy priorities completely appropriately. Now, I suspect your follow-up question is, all right, so how do you keep those prosecutors and investigators free of political influence?
Yeah, let's get more fine-grained. Let's talk about charging decisions.
Yeah.
So I teach criminal law to first years, and one of the things you learn when you learn about criminal law, I mean, there's lots of surprising things one learns as a law student about the criminal law. One of them, I think,
there's a lot of
is
it.
there's so much of it. There's so much. And there's this thing called prosecutorial discretion, which is a product, which is both intrinsic to the system, but also a product of the amount of laws that there are on the books.
Yeah.
A good prosecutor can charge someone with so many potential crimes, and it's up to the prosecutor. And so when I hear you say, on the one hand, there's the legitimate policy objectives, and on the other hand, there's prosecuting crime, and these are separate, I'm not so sure they're separate. There are going to be there are choices about where to expend resources when it comes to charging all the time. So how do you make these choices? Who makes these choices? And how do you ensure that they are free from what you're describing as partisan influence, but still subject to the policy imperatives of the administration?
Sure, and the policy imperatives are okay, right? Because it is a policy choice. So let's take my hypo, right? We got a lot of law students, let's take a hypo. My hypo was the policy choice is healthcare fraud. That is a perfectly legit policy choice. Now, you might, if there are rising crime rates, you might take some political heat for putting all of your focus on healthcare fraud versus violent crime or the like, but it's an appropriate or a reasonable policy judgment to make. You can make that judgment and you'll answer, those political actors or policymakers will answer at the ballot box, but it's an okay judgment to make when it comes to the role that the Justice Department plays. Now, how do we then, whatever the policy priority is, the enforcement priority is, how do you make sure that you're making those choices free of extrinsic influence? Now, look, the reality is we're all people. It's not like you kind of become a federal prosecutor and you undergo a brain transplant and you don't actually have views. But we do have what I referred to rather as the principles of federal prosecution. It's a set of guidelines and guidance to prosecutors to say, here's how you should undertake what is frankly an awesome power, and by awesome I don't mean cool, I mean really expansive and significant, right? Here's how you should structure your decision making, right? And first is the conduct that you're looking at, is it a violation of law? Is it a federal crime? Okay, we've already established there's lots of that, so. Second is, do you have sufficient evidence to obtain and sustain a conviction, okay? Is there a substantial federal interest that will be advanced by pursuing this case and not the next case, right? Can that case actually be pursued equally well or better in another jurisdiction, right? Can a state court handle it? Should the state prosecutor handle it? It's why you don't see federal prosecutors doing a lot of general criminal enforcement, right? Or even very significant crime like murder, unless there's a federal interest or a federal law has been violated. And then, importantly, is there a non-criminal alternative? These are all laid out in the principles of federal prosecution. And that is how prosecutors are taught to structure their decision-making. Because although you've heard about the vast resources of the federal government, let you in on a little secret. It is not limitless, okay? So we also have to choose how we deploy those resources. But then very, very, very importantly, we also have something called the Attorney General's guidelines. And these also lay out kind of the boundaries, the guardrails for how we undertake our investigative and prosecution mission. So you cannot undertake an investigation for something that is solely, and this is near and dear to your heart, First Amendment protected conduct, right? You cannot investigate somebody for exercising their First Amendment right. And again, if you go to the principles of federal prosecution, it's laid out there in black and white. It says you cannot consider extrinsic issues, right? You can't be influenced in undertaking this prosecution decision by somebody's race, gender, and other considerations, right? You can't take into account or factor in your own personal viewpoint, how this investigation or prosecution may influence your own personal views. So that's all laid out in the principles of federal prosecution. That's how we are guided, and of course, guided by the AG guidelines and the Constitution.
Now, these are important principles, but they're also decades-old principles. They've been organizing the department for, I mean, of course, they change over time, and the Attorney General's guidelines change with every Attorney General. But these are pretty familiar, basic constraints in the way the DOJ operates.
Yeah.
But has anything changed? You know, the question today is the increasingly fractured, polarized nature of American society. For example, you know, do you worry when you're making charging decisions? And actually, I want to ask more about who's making the charging decisions and how much control there is over those decisions. Are there concerns about political fallout if some decisions are too politically costly or too distracting from the administration's business? You know, the reality of doing politics, I think, today is that there's a lot of negative press, a lot of oppositional tactics, and so how do you take that into account when you're making these decisions?
So first, who makes the charging decisions? In the vast majority of cases, it's career federal prosecutors, right? So these are men and women who are not political appointees. The Justice Department is made up of nearly 116,000 individuals, okay? Law enforcement agents, investigators, analysts, prosecutors, attorneys, economists, scientists. We've got folks from a whole range of disciplines. And the vast majority of charging decisions are made by career federal prosecutors. Now, some require greater level of supervisory approval, depending on, so for instance, a significant hate crimes investigation or a terrorism investigation. So I was the head of the National Security Division, which was the first new litigating division created in the Justice Department since the Civil Rights Division in the 60s, and it was created, the National Security Division was created after 9/11 to bring together the intelligence function and criminal prosecutors to prevent and prosecute terrorist acts, espionage acts. And those charging decisions, for instance, in terrorism cases, had to be approved by me. Why? Because we wanted to make sure both that there was a national viewpoint on what at the time, terrorist threat was, and that we were using those statutes, those very, very powerful statutes, in a consistent way. So that's the answer to who's doing them. How do you do your best to keep those judgments free of extrinsic influences? A few things. One is by trying to adhere to norms of practice and procedure, things like the White House contacts policy that I mentioned, that Attorney General Levy put in place. He put in place what's called the White House contacts policy, which every Attorney General has had in place, some version of it, since the 70s. And that governs how and whether, in very strict circumstances, there will be any discussion between the White House and the Justice Department on criminal enforcement issues. And that is to guard against some prosecutor, we call them line prosecutors, right? An assistant US attorney who's investigating a case, maybe it's a sensitive public corruption case. Imagine if that prosecutor gets a call from somebody high up in the administration, somebody who works in the White House, and says, you know, maybe you should lay off that guy. That is verboten. That is, and that AUSA knows to call my office to say that is unacceptable. And why do they know that? Because we've issued this guidance, the Attorney General Garland issued this memo, his version of the White House contacts policy, to make sure everybody knows that type of contact is unacceptable. So putting out and being very clear, those are the guardrails, and this is what we expect. Because it's our job, the Attorney General's and mine, to make sure that our prosecutors and agents are able to do their job free of any of those types of considerations.
I mean, your answer, which was really interesting, makes me want to ask about another aspect of doing justice today, which is doing justice in the aftermath of the Trump administration, and how do you deal with the legacy of the Trump administration. So there is widespread concern, I think, among lawyers and others that under the Trump administration, many of those guardrails were not strictly observed. There were violations of some of these basic norms. And when you were nominated to your position, you said that the DOJ stood at an inflection point, using your words again, and that the department had to recommit itself to the promise of equal justice. Now, I take these statements to articulate an implied criticism of the DOJ under the Trump administration, the need to recommit, and a criticism, again, that is widely shared. So how do you, in practice, recommit the DOJ to this promise of a nonpartisan justice? How do you deal with the legacy of a prior administration and a prior DOJ? So, for example, again, getting more fine-grained, as all of the law students in the room know, individual cases can take years and years to wend their way through the system. So the Biden DOJ, to put it, is going to be dealing with a lot of cases that were initiated under the prior administration. So how do you ensure that the decisions to continue to prosecute these cases are good ones?
Well, look, one is, as I said before, making sure that those decisions are guided by, and we are articulating our expectation that those judgments, those charging decisions, those continued prosecutions are adhering to things like the AG guidelines, things like the principles of federal prosecution. But it's interesting because I get asked about quote unquote controversial cases a lot. Now, one person's controversial case is another person's righteous prosecution, right? The point is that our job is to enforce the law, to do so, as I said, consistent with the principles that I laid out, and to do so in a way that is consistent with the rule of law, meaning that the basic premise, and Attorney General Garland talks about this a lot, the central norm, we talk about making sure we are abiding by norms, right? The central norm for a rule of law system is that there's one set of rules. That same set of rules applies regardless of who's on the other side of the V. United States versus Monaco, United States versus Lake Erie. It shouldn't matter who's on the other side of the V, how rich and powerful they are, whether they're a Democrat or Republican. We've got to apply the facts and the law consistently regardless. And it's our job to do that. Now, you say, well, how do you avoid controversial cases? Our job isn't to avoid, and we don't spend time avoiding controversy or sensitivities. What we do avoid is making decisions based on political considerations, whether that's who you're going to, quite frankly, piss off, or whether or not you're going to get heat from action or inaction. I had my first boss I referenced was Attorney General Reno. She had a phrase that stuck in my head from the very earliest time that I spent with her. And she got a lot of heat in her day as Attorney General. She used to say, I'm damned if I do, damned if I don't, so I might as well do the right thing. That's pretty good guidance.
Okay, but it's not only controversial cases. So again, just to get specific. So for example, in a case that came to light in June, I think, of last year, there was news reporting that lawyers from the DOJ under the Trump administration subpoenaed Apple for information about the records of Democratic members of Congress without letting those members of Congress know it, without informing the proper channels. And I think you referred this matter to the DOJ Inspector General for review, after which Attorney General Garland tasked you, generally he announced, with surfacing problematic matters deserving high-level review. Fun job, I'm sure.
Yep.
And you've talked a lot about norms and being normatively committed to doing the right thing. But I guess two questions here. One, should there be a general Inspector General position set up to surface, to do the thing that the Attorney General asked you to do, but I imagine you have many other things on your plates, to look for problematic cases initiated under the Trump administration? That is to say, is someone doing many other tasks enough to do this job? And is it enough to rely on norms, on the good faith behavior of members of the Department of Justice, when we might worry that we live at a time when commitment to these norms, these fundamental norms of equal justice and democracy, are not as firm as they used to be and perhaps asymmetrically applied?
Yeah, look, I mean, this is a kind of uber debate that I think folks have been having now for a while, which is, should we be putting soft norms into hard laws, right? Should we codify some of these norms? And it's a reasonable debate to be having. I guess what I would say to that is, at the end of the day, you've got to rely on people to either observe the norms and guidelines like the principles of federal prosecution, the White House contacts policy, and you got to rely on people to adhere to the law, right? So at the end of the day, you still need to have confidence in the people in these positions, because they're going to be the ones either adhering to or not the norms, or applying or not the law. So I think we can debate at the kind of edges whether some things are better as a law or some better as a norm. But at the end of the day, it depends on people of good faith and people being held accountable. So to your IG question, look, the Inspector General, I referred that matter to the Inspector General because I thought it was appropriate for somebody who is independent within the Justice Department to undertake that review. And he will do that amongst a whole range of other things, and can make criminal referrals, can make administrative recommendations, can make management recommendations, and inspectors general, and this one is an excellent one, do that across administration. So I do think that's an appropriate way to go, and was an appropriate thing to do in that instance.
I mean, other than that, though, we haven't seen a whole, as far as we know. So I guess I should phrase this as a question, because you're here and you can't escape. Have there been efforts to make other kinds of reforms, institutional reforms to the DOJ, to avoid repeating whatever errors may have occurred or crimes may have occurred under the Trump administration? I mean, you say correctly that it's people who ultimately have to enforce all the laws. No rule is going to be enforcing itself, and so we constantly have to worry about how effective our mechanisms of enforcement are. On the other hand, I'm a law professor. I spend a lot of my time telling students that the institutions we build matters, and the way in which we structure our institutions, our flow of information, our relations of authority and hierarchy, and transparency obligations, right, what we make public, all affect the likelihood or the unlikelihood of rules being followed. And so is there a desire, is there an effort, or do you think, is there a need for there to be sort of more structural, systemic reforms institutionally to avoid the problems we've seen in the past? I mean, earlier you brought up the example of Watergate. And the thing about Watergate, it's a really interesting counter in a way, because of course we think that our problems today are so bad and we forget that we have had political crises before. But after Watergate, there was a profound reorganization of many aspects of the national security state in particular in order to avoid a similar repeat. And it doesn't seem to me like we've seen a similar systemic reorganization in the wake of the last 4 years.
Well, look, I think you're seeing efforts on the Hill. You're seeing the January 6th Commission undertake its work. And it's appropriate for policymakers and folks on the Hill and others, and law professors and law students and policy students to debate these things and to make recommendations, right? Our job in the Justice Department, and I say this a lot. I say this to students that I talk to. I said it when President Biden nominated me. I think the job and what is great about the Justice Department is the career men and women who steward that department regardless of the political winds, right? And it is the job of people like myself, the Attorney General, the other leaders in the department, to be very conscious custodians of that institution. That's what I took away from Attorney General Reno hanging that portrait of Ed Levy in her conference room. That was a signal to everyone who entered there that those norms, those changes, those guidelines that 20, 30, 40, 50 years on should be adhered to. That was her signal that we are all custodians of the institution. And the way we are good custodians, in my view, is by maintaining those norms. If they need shoring up, we should do it, right? Which is why Attorney General Garland announced his own version of the White House contacts policy. And if you read it and compare it to others, I think he's shorn it up in certain spaces, right? Which is why we adhere to, even though it frustrates many people, the norm of not talking about ongoing investigations. right? It is incredibly frustrating, I think, to many people that we don't talk in detail about specific investigations. And there's very good reason for that. And I think, frankly, we in the department need to and should be doing more to discuss not the specifics of an investigation, but how we work, why we don't talk about the specifics of an investigation. And here's why. This is one of the ways we try and insulate charging and other decisions from extrinsic influences. Even as important a value as transparency is, and it very much is, particularly for those of us in government who wield enormous power. Transparency is exceptionally important, not for transparency's sake, although that is important, but because it allows people to evaluate how we are wielding power in their name, right? So that's a very important value. By the same token, we in the Justice Department have another responsibility, a legal responsibility, a constitutional responsibility to ensure that our investigations have integrity. So on the one hand, it means making sure that we don't describe our investigative steps such that those investigative steps are thwarted, that evidence is hidden or destroyed, or witnesses decide they don't want to come forward. And equally importantly, we don't talk about people whose conduct we haven't charged, right? We don't cast suspicion or talk about people who haven't been charged because it's unfair. People are entitled to due process, right? We've all heard people are innocent until proven guilty. We only speak about conduct that we have put in a court document and are willing to prove up in court. And that's an exceptionally important value to uphold. And I think people, we all who are interested in justice, the value, not the department, can appreciate that we don't try somebody in public opinion or even in Ida Noyes Hall unless we are willing to bring that information forward into court. And I think that's an appropriate thing, and we have to be very conscious about how we're balancing both that important value of transparency and letting people know that, yes, we are on the job, with guarding that norm of making sure our investigations have integrity and we are protecting and guarding the rights of those who we have not charged. And I think what you saw, for instance, in the Attorney General's speech on January 5th, the day before the first anniversary of the attack on our democracy at the Capitol, was an explication of these principles. Even as we are balancing those two values, the Attorney General gave an update, described what we were doing, the 800, now nearly 800 people who have been charged, including 200, more than 200, who attacked federal officers. And so he described the work we are doing because it is so important to give people an understanding of what we're doing. Now look, we're not going to be able to, as we balance these two transparency values and our responsibility to adhere to norms about integrity of our investigations, as we balance those two things, we're not going to please everybody. But the job is not to please particular points of view. It is to uphold the rule of law and act consistent with our charge, which is to operate consistent with the facts, with the law, with the principles of federal prosecution.
Okay, great. But since you did bring up January 6th and
Yeah.
the prosecutions against the January 6th defendants,
Yeah.
I did want to ask about that. And again, you made clear you're not going to talk about any pending cases individually.
Because I'm adhering to
But
the
I'm a
norms.
law professor, and
Yeah.
I love knowing generally what's
Yes.
going on and understanding
Sure.
structures and systems
Good.
and approaches and balancing tests. That's great. So as a prosecutor, I imagine it's a quite difficult task to think about who to prosecute, how to go about the business of prosecuting this event, because it is now incredibly politically divisive. The Republican National Committee has described the insurrection as a legitimate political discourse. On the other hand, there are those who think that it represents a fundamental threat to democracy in the United States. These are vastly divergent points of view. So when you, as a prosecutor, are thinking about the task of potentially bringing charges, how do you weigh these competing considerations and the impact this is going to have on the American political system? Are you saying it's totally irrelevant altogether?
No, look, we don't operate in a bubble, right? But what we do is investigate conduct and crimes, not people or viewpoints, okay? So the January 6th investigation, now more than 800 people charged. As I said, more than 200 charged with and arrested for assaulting federal officers. 10 who've been arrested and charged for attacking members of the news media and destroying their equipment. I could go on and on. Our court filings and public video that many of you have seen details significant violence, people using poles and other dangerous weapons to beat, in many instances, officers, to engage in violent conduct in an effort to thwart and obstruct what is a fundamental act of our democracy, which is the peaceful transfer of power. We've now had 3 individuals who are members of the Oath Keepers organization plead guilty to seditious conspiracy. And that, in their plea statements and in our papers before the court, indicate that they engaged in a plan to use all means, including force, to obstruct the peaceful transfer of power. So how we go about making these decisions, first, we look at and investigate the crimes in front of us, right? And then we work our way up. We follow the facts, we follow the evidence, we follow the money, and have our investigation go out from there. And it's very important to do that in a methodical way. Why? So that people don't think you are starting from an assumption, right? If you are starting from that which is in front of you and investigating those facts and letting the facts guide you, not letting your assumptions, not letting viewpoints guide you, but starting at the bottom, as it were, and working out from there, that also, I think, should give people confidence that we are investigating conduct, not people, and not viewpoints.
Do you feel any pressure, though, in an increasingly fast media environment where news is constantly breaking to, I mean, this goes back to the earlier question about the trade-off between transparency and impartiality or integrity. That's an old trade-off, but it's a new media environment. So I was curious, did the DOJ have a tweeter? Do you think about social media? Do you worry that not speaking more than you do about cases allows those who want to misinform or spread conspiracy and rumor a lot of room to maneuver? How do you deal with this new weaponized information environment?
Look, it is a new environment, and I'm concerned about what that environment does to aid or propagate violence and threats of violence. I can't be as concerned with Twitter or commentators trying to work the refs, so to speak, in terms of the actions we take. We've got to be guided by the facts and the law and working out from there, because I think that is the thing that can give people confidence that we are, in fact, doing our job. Now, you say, but
so no dedicated tweeter?
No dedicated, well, I think our public affairs office does have and I'll just say it for this crowd because I hope he's not listening. It's a pretty boring Twitter account. But that's what you would expect from your Justice Department, I hope. Look, it is, I think it is something that we're actively, constantly evaluating, right? How do we do this balance of the importance of transparency and public confidence that we are doing our job as public servants, right? While making sure, we just spent an hour talking about adhering to norms. right? There are laws, as well as the Justice Manual, our own internal guidance and policy that says I'm not, and DOJ employees are not supposed to talk about cases outside the four corners of our court documents, right? Those norms, those guidance documents, those policies, let alone the federal criminal law that says it's a crime to talk about what you did in the grand jury, right? And we're bound by that. If we don't adhere to those norms at times of great tumult and unusual behavior, then what are they there for, right? My own view is we abide by norms and policy, especially in unusual circumstances, because that's what keeps our ballast, right? That's what keeps those norms strong and reliable.
Do you worry, though, that in a future administration it may be staffed by people who are not so committed to norms and balance? Look, I mean, you've talked a lot about self-discipline,
Yeah.
right? About being a particular kind of lawyer, doing a particular kind of justice. But again, we are in this, strange territory where people have very, very different views about what the role of the Department of Justice should be and who their exemplars are, and everyone is not looking at Ed Levy.
Yeah. Well, look, I worry that we do our job to keep those rule of law muscles strong, right? I think that is our job as custodians of the institution. And I take it exceptionally seriously. The Attorney General takes it exceptionally seriously. And I think if we are doing that, the 116,000 men and women of the Justice Department are waking up every morning, keeping their head down, doing their job, and it's our job to make sure that they've got the tools and the norms to do that job.
Okay, so I'm going to turn to student questions very soon, but so I have one final question
Okay.
that I think it's my responsibility to ask. And again, I know you're not supposed to talk about pending cases or uncharged cases. You don't want to prosecute anyone in this theater, so I'm just going to ask you a hypothetical, not about any real person, just a hypo, like I do every day in the classroom.
Okay.
Which is, you're the Deputy Attorney General, and you have some power to decide what Department of Justice goes after. And there's former high-ranking members of the administration who are no longer in the administration. Mm-hmm. And there's plenty of suggestive evidence, and maybe some federal judges have found there to be quite a lot of evidence that they have committed crimes. So how do you go about the process of thinking about whether to charge them? How do you talk to the American public about that process? How do you do it?
CEG, the last hour.
Yeah,
Right.
It's no different. There's,
No.
when thinking about charging the highest federal official and a regular person.
One set of rules, no matter who's on the side of the V, right? That has to be the right answer.
And so it's just, if you have enough evidence, you're
Right,
going to
Professor?
charge.
Doesn't that have to be the right answer?
Well, in my class, we talk a lot about a thing called prosecutorial discretion,
Right.
And how much power this gives prosecutors to make difficult choices about
Right.
where to mobilize resources.
That's exactly right. That's exactly right. And so we look to the policy and the process that guides that decision-making, right? And then when it's appropriate, if we've decided to bring charges, we'll talk about those charges, right? We won't talk about the uncharged conduct. And it is important to talk about the work that we're doing. So for instance, I've spent a bunch of time in the last month talking about what we're doing to go after Russian cyber attackers, right? What we're doing to go back and seize back assets from Russian oligarchs as our part of the whole of government effort to respond to the horror that's happening in Ukraine. It's important for us to talk about that as a priority so people understand the steps we are taking in their name to address the aggression that's happening in Ukraine. That's an example where we're taking steps, we're talking about the work that we're doing, but we're doing it in the context of specific enforcement action that we've taken and where we can point to conduct that we will either prove in court or put before a judge in a forfeiture action.
I guess I'll say follow up, because maybe I don't see any students at the microphones, but I think if students have questions, please go up to the microphones. Just as a quick follow-up.
Sure.
I mean, thinking sympathetically, one might imagine that if you're a prosecutor and you've got lots of cases to charge and there's lots of bad behavior to go after, you might think that the profound political fallout that might follow going after a particular individual will distract generally from the work of the Department of Justice, and in the long run, undermine the people's justice. So I guess I'm wondering, are those kinds of concerns, not with the, oh, we don't want to charge this person because of their rank, but we don't want to charge this person because it's going to make our lives of doing the people's justice so much harder. Do those kinds of considerations come in?
Look, I'll quote the Attorney General here. We don't avoid specific cases because they're controversial or they're sensitive. We do avoid making decisions based on purely political or partisan considerations.
Okay. Questions?
Hi, my name is Graham Harwood. I'm a first-year student at the Harris School of Public Policy.
Hi.
Hi. So you talked a lot about norms, and how do you think about the kind of collision of non-legislative or judicial precedents, such as like the norms that are in briefs that are published by the Office of Legal Counsel and the Justice Department? How do you think about overturning or going against old memos that were neither voted on nor ruled on by the judiciary branch?
Yeah, it's a really good question. This is an issue that confronted the Office of Legal Counsel in particular at the beginning of the Obama administration, where there were a set of OLC opinions that the new leadership of OLC decided to undertake a review of. But they did so pursuant to a set of principles and kind of guidance of how they were going to look at those, right? So a very lawyerly thing to do, right? To not do it on a one-off basis, but to say, here are the principles that are going to guide how we review OLC opinions. And then they made that transparent. So you can go to the OLC website and you can look at those principles and you can see, and they're being adhered to by the current leadership of OLC.
Now, you can't see all the OLC opinions. Many of those are
That's
secret.
right.
So has there been any desire to make the OLC opinions, including maybe in particular the ones issued under Trump, public?
So this is where I would point you to those set of principles, which is to say, unless there is a reason to keep particular opinion secret, does it deal with classified information? Does it affect a particular, for instance, national security operation that may be ongoing? Those are considerations why you wouldn't publish that particular guidance. It may be so particular to a lawyer-client discussion that those of you who are budding lawyers in the room, you'll know you want to keep that advice privileged and confidential, so your clients will continue to share things with you. So those are the types of judgments that get made. But in many instances, there is a presumption to, in fact, publish those opinions for all the reasons that you would imagine. So you can see what is the judgment. Of course, OLC is binding on the executive branch, right, is the definitive word on interpretation for executive branch employees as to what a particular law does or does not do.
Another question?
Hello, my name is Divya Marothra. I'm a first-year student at the college, so the undergraduate college.
Right.
So Attorney General, sorry, I'm a bit short.
I hear you.
Glad to hear that someone understands. Attorney General Merrick Garland recently announced the Climate Office underneath the Department of Justice. So I wanted to ask two questions about it. First is, how does this differ from previous prosecutions in that arena? And then second, what is the first priority of the Department of Justice in regards to climate issues and this new office?
So what the Attorney General, just for all of you who don't know, he announced last week the creation of an Office of Environmental Justice, right, which is a separate office within the Environment Division of the Department of Justice, which is a set of lawyers with both civil and, in some cases, criminal authorities to go after violations of environmental law. And this was the first time that there's been a specific focus on issues of environmental justice. And we had kind of a robust discussion about, well, how should we set this up? Should it be in the Environment Division? Should it be somewhere else in the department? And we settled on the Environment Division. But importantly, to make sure that we've got experts, for instance, from our Civil Rights Division involved in those discussions and involved in that enforcement work. So what you're seeing here is, I think, pretty unprecedented specific focus on carrying out issues of enforcement when it comes to environmental justice, when seeing communities that may be disproportionately impacted by violations of certain environmental laws and the like.
Hi, my name is Marie Artie. I'm a second year at the college. I had something of a specific question about resentencing hearings. There's been a sort of a broad trend in certain states of revisiting sentencing guidelines and making some of those changes retroactive. And I know that there's been litigation at the Supreme Court about specifically the First Step Act and whether judges must not, or should consider changes in the law. So I was wondering if you could speak to what those hearings generally look like. Are they ever adversarial? What kind of evidence is a judge considering when they use their discretionary judgment to decide whether or not to reduce a person's sentence?
Yeah, so the First Step Act was a really kind of path-breaking piece of bipartisan legislation passed in the last couple of years that both paved the way for those who are incarcerated to earn more credit on their sentence by participating in reentry programming and rehabilitative programming so they can be productive members of society when they leave incarceration. And the First Step Act also had a number of provisions in it to allow, in some circumstances, those individuals who had been subject to very serious sentencing, particularly under certain drug laws, to have their sentence re-looked at by a judge. And frankly, there's a debate, as you said, in the Supreme Court, which I won't get into because it's pending litigation. But importantly, one of the things that I hope will happen is with a new nominees to the Sentencing Commission, which, as you probably know, has a lot of influence and can set a lot of guidance as to how litigants do interpret the sentencing guidelines. I'm hoping for the first time in quite some time we can get the Sentencing Commission to a quorum, which it doesn't have right now, so it's kind of hard for it to do its job, to be able to make some inroads in this particular area.
Presenting arguments to a state legislature that it should pick electors other than those that the popular vote chose because the candidate who lost would make a better president could be regarded as protected speech, would be protected speech. But alleging specific facts that you know to be false could be regarded as perpetrating a fraud on the legislature. And so there's a kind of clear norm, but if one were to make a prosecution for seditious conspiracy on those grounds, there would be many other elements that would have to be proved that turn on many other norms. And even though there's a kind of overarching norm that the person who loses the election should cede power, there's, in a way, such a complicated set of norms, and it's such a unique case that it could be regarded by one side as a novel prosecution based on novel theories, whereas the other side would say declining to prosecute would be political because it's regarding somebody, the leader of a movement, as too powerful to prosecute. So how do you navigate, how do you make sure the rule of law can protect the rule of law under these circumstances?
Did Genevieve put you up to that?
$5. Look, everyone's corrupt.
Look, you know, you cited the issue around electors. I'm going to stay pretty far away from that because I have already acknowledged that the issue of alleged fraudulent electors is something that is under review by the department.
Okay, I guess I'll ask a variety of bad questions.
Yep.
I did not put him up to it, but I am curious about this.
Yeah.
Which is, again, going back to January 6th, you say you just follow the law, but there is so many laws, and they're generally quite broadly worded, for example, seditious conspiracy. And so, again, I just want to know about the trade-off. So far in the prosecutions, although I understand that everything's not over yet by any means, most of the people who've been charged are those who were directly involved in the events at the Capitol. But we know that there was plenty of organizing, inciting, encouraging, and we might think that many of those who were involved in the organizing, the inciting, the encouraging perhaps bear more responsibility than those who participated, or equal responsibility, and yet it does raise difficult First Amendment concerns. So in thinking about how high to go, how broadly to go in these prosecutions, when we move beyond the people who entered the Capitol to people who were involved in the planning and the orchestrating, how do you think about the free speech concerns? And also, how do you think about this excellent question about prior precedents? You know, how conservative do you play it? Do you worry that if you are going to be conservative, the result is going to be an overly anemic sort of a form of justice?
So a few points. One, on the question of how broad to go, how high to go, we've been exceptionally clear about this, and let me restate it and be clear here. We will follow the facts and the law wherever they go to hold perpetrators of January 6th accountable at any level, at any level. We will do so whether or not individuals were present on that day or not. So we've been exceptionally clear, and I want to make that clear here for this audience. When it comes to making judgments about how to make these charging decisions, seditious conspiracy. I mentioned 3 pleas already to seditious conspiracy. It won't take a huge law school paper writing exercise to look at the history of the seditious conspiracy statute. As the professor here can tell you, it does not, you won't find a lot of cases, right? So something we take very seriously, and we appropriately, I think, brought these charges, which I'm not going to expound on beyond what is in the charging papers, except to say that we think it appropriately gets at the gravity of the conduct. And again, we've gotten 3 guilty pleas to that particular statute already. Last point on how do we make these decisions. You know, I talked about starting first with the crimes that are kind of in front of us, right? And then working out from there and the reasons for that. I think what you see in the charging decisions that we've made, the most serious charges and frankly thus far sentences have been meted out against those individuals who engaged in assault. The 200 plus individuals who I said who we've arrested and charged with assaulting officers, right? Or members of the news media. Those who engaged in conspiracy acts to obstruct the peaceful transfer of power. Those are the most serious charges and thus far are garnering the most serious charges and ultimately sentences most likely. Then where that conduct is not present, either assault or conspiracy to obstruct the peaceful transfer of power, you see us using lesser charges, right? For those who entered the Capitol without authorization, trespassing and the like. It is important to mete out those charges as well. However, you're seeing those individuals both coming forward and taking responsibility, getting lesser sentences, both because they are lesser charges and if they've come forward, accepted responsibility, and in some instances cooperated with the government, you will see lesser sentences and lesser charges there.
Okay, I think we have time for one last question from the student. Do you want to take it away?
Afternoon. Thanks for being with us today. I found it very enjoyable. My name is George. I'm a first year in the college, and so while my understanding and skills with hypotheticals probably isn't quite up to scratch, I'm going to try my best because I think this is going to be a question that is in the minds of a lot of the audience. Thinking about kind of a departmental interpretation of the Constitution, say that there was one department who read contrary to the opinion of a different department, one that might govern the Justice Department, certain rights that can be found in the Constitution. How do you, and you've talked a lot about norms, rigid structures that guide the Justice Department, and I would imagine over time those have only become more robust and more intricate since historical instances where the Justice Department might have read the Constitution a little bit differently than other departments. I think back to Dred Scott, and I think Abraham Lincoln's Attorney General acted a little. Edward Bates acted a little bit contrary to what Roger Taney might have wanted him to do. How do you view in the modern era where these institutions are more complicated, are far more disparately organized, and the structures are a little bit more rigid than they used to be. How do you view the role of the Justice Department in interpretation and execution of the constitutional rights that are questioned by some departments of the government and viewed
Well-
differently by others?
Well, the good news is the other departments of the government don't have the power to enforce the law or prosecute anybody. That is solely, when it comes to federal law, the job of the Justice Department. And then we defend or don't other parts of the government when they get on the wrong side of some of those interpretations. So for good or for ill, we say what goes, and as I said, the Office of Legal Counsel is the definitive voice in the Justice Department on, and ultimately the Attorney General, on what the executive branch interpretation of federal law is.
Okay, I think we still have 5 more minutes, so
Okay.
2 more minutes. Okay, 2 more minutes. Oh,
Two more questions.
Okay, 2 more questions, and I'm just going to.
And I won't filibuster. How about that?
I will try and be fast.
Okay.
So my name is Eve. I'm a second year in the college. So when considering cases like Alexander v. Sandoval, in which the Supreme Court struck down cases that challenged racial biases in the criminal justice system, which were obviously affected by personal and political biases, how can we move forward from here towards equality with these as a precedent in terms of like overturning them?
So the Attorney General has been very, very clear that the enforcement of and upholding of civil rights is foundational for the Justice Department. He talks about it being in the Justice Department's DNA. The last questioner talked about Abraham Lincoln. In the Reconstruction era, the Justice Department was basically set up to, its first job was to enforce the civil rights laws, right? To go after and enforce the Ku Klux Klan Act, right? People who were persecuting and going after newly enfranchised African American citizens, right? So when you think back, that is the history of the Justice Department. It was founded to enforce our civil rights laws, and obviously has had a long, distinguished, and sometimes complicated history in that regard. But he's been very, very clear that, yes, we have a civil rights division, but upholding and enforcing our civil rights runs through everything that the Justice Department does, whether it's prosecuting hate crimes, whether it's addressing domestic violent extremism, whether it's prioritizing environmental justice, whether it's going after and enforcing voting rights laws. Those all have a line to our responsibility to enforce and uphold civil rights laws.
Of course, some of these initiatives have generated their own political reaction.
Yep.
So, for example, I know that the Domestic Terrorism Task Force, which was created under Attorney General Garland, has been heavily criticized. I think Chuck Grassley said it's politicizing the Justice Department. How do you balance, again, this concern with political blowback against these sort of more creative initiatives to create new areas of concern for the Justice Department?
So look, I think we have to be grounded in facts. We have to be grounded in data, right? So that is a response. The National Security Division, the division I used to have the privilege to lead, is responding by creating a unit within the division to focus on domestic terrorism issues, is responding to what the FBI and the intelligence community has said is a disturbing rise in the level of threat when it comes to domestic violent extremism, regardless of what ideological root that extremism may have. So we have to be rigorous in grounding our efforts in facts, in data, and be responsive to the threats, whether it's foreign terrorism or domestic terrorism.
Okay, great. Okay, last student question.
Okay, great. Sorry, I'll try not to hold everyone over. My name's Kate, I'm a 2L, so I'll try not to embarrass the law school too badly here. I would hate to embarrass your alma mater, but we've talked a bit about prosecutorial discretion. Obviously, you shouldn't bring charges because of something like a protected class or political views. I'm going to very tactfully segue off that to introduce a brand new topic with our last 2 minutes here. But as state and local law enforcement and state and local courts are starting to experiment more with using AI and machine learning in a lot of decisions, what are the discussions going on at DOJ about using AI ML tools in prosecutorial charging decisions? What are the due process concerns and the equal protection concerns?
It's a great question, and it's new technologies and emergent technologies are something we have to both recognize the promise of and how it can help, from both investigative work as well as how it helps us in a whole host of scientific discoveries, right? We have to both realize the promise there, but do so very clear-eyed that these are tools that can be abused. So one of the things I did when I first got back to the department was undertake a comprehensive cyber review of all of the cyber issues that cut across the Justice Department, including the use of certain technologies. And what I asked for was a set of recommendations on what should be the principles that govern our use and procurement of AI technology, and how do we put that to use. And I'm looking forward to getting those recommendations very soon.
Okay, so we unfortunately are out of time. So I wanted to thank the Deputy Attorney General for coming.
Thank you.
Having this great conversation.
Thank you. Thank you very much for having me. Thank you for letting me have a little trip down memory lane and return to Hyde Park on such a glorious day. And thank you, Professor, for putting me through my paces.
It's my job. Thank you all for coming.
Thank you.
Bye-bye.